Okay. Thank you, Deputy. Counsel's ready for the jury?
Mr. Gray will be here.
Oh, okay.
You want one? Yeah. I got one back there. I want that.
All right, yes. Okay, please be seated. All right, good morning, members of the jury. I was pleasantly surprised that we didn't have the icy roads that we thought we were going to. So, all right, does the state have any further witnesses?
Good morning. No, Your Honor, the state rests.
Okay, members of the jury, I need you to step out for a couple minutes, about 10 minutes. All right, please be seated. Okay, Mr. Ng, you had a matter that you wanted to bring up.
Your Honor, the state has now rested. The defense moves for a judgment of acquittal. I realize that the facts are construed most favorably to a potential verdict and consistent with the guilt. On the other hand, the testimony is confusing at best. The theory advanced
yesterday is that a taser was inappropriate to be used. That was an opinion of Mr. Stoughton. The testimony, though, has been that the taser was reasonable to be used. So the state has presented witness after witness, either on cross or direct. I'm speaking of Peterson Lucky, for example, who've indicated that the taser was quite reasonable to use, should have been used. I think they were pleased that it was used, or at least something was done. So we have sort of this discordant presentation. I mean, if the theory of the government is that the taser is inappropriate, then they've presented conflicting evidence to that opinion. If the theory of the government is that the taser was appropriate, then the expert's opinion is inappropriate. And that also goes for the use of deadly force as well. I mean, we have Johnson's testimony and Fleshling's testimony, and we have Stoughton's testimony. So it's a confusing mess, really. And I say that in all due respect to my colleagues on the other side. When you denied our motion for the judgment of acquittal on the manslaughter count, one, the opinion was, of course, thorough and well done, but it also commented how the probable cause standard is quite de minimis compared to the standard of proofs beyond a reasonable doubt. And so they still have to show that, at the moment, and it is a standard at the moment, she thought she was employing her taser, and everybody agrees to that she had a knowledge that she was about to commit a violent act, and with that knowledge, however obtained, disregarded that knowledge. That's really a high burden to meet under those cases we've been talking about. So while the probable cause was perhaps suitable to satisfy both charges, which are related to each other, really. I mean, the consciousness of guilt and the first degree standard are quite similar. The evidence in our view is insufficient. We request that you dismiss both counts, but particularly the Man 1 count, which the court had already discerned is quite weak. And nothing has happened here to make it stronger. I also want to make an offer of proof consistent with what we were talking about yesterday. I can do that now or wait on that. I defer to the court's discretion.
Okay, why don't we let the state respond to the motion for judgment of acquittal first?
Thank you, Your Honor. My understanding,
Sorry.
habits, yeah. Your Honor, the standard for taking a case from the jury's hands is actually quite high. I think the court has to basically issue a summary judgment that there's no way under the set of facts presented to the jury they could arrive at a guilty verdict. That certainly has not been met here. I take it from counsel's argument that the real challenge is to the recklessness or carelessness elements of the statutes. I know there have been arguments made about causation, and I'm sure will be made, but pretty clear the testimony that the court heard was that the bullet that Ms. Potter fired into Mr. Wright's chest blew up his heart and killed him within minutes. That's causation. The elements of recklessness, Your Honor, as you know from the jury instructions you've crafted carefully, talks about a reckless handling or use of a firearm for the first-degree manslaughter charge. Here we have a 26-year veteran of the police department who was trained every year in how to handle her firearm and had to qualify every year to handle her firearm, carried it when she was on duty, and yet did not know she had her gun in her hand when she shot Mr. Wright. I think the facts bear that out on her statement alone, which the court and the jury has seen. That is raises the issue of the recklessness of her act. She committed a conscious or intentional act in drawing the firearm. There was evidence that she prepared to do that. She pulled it out of her holster, pointed it directly at Mr. Wright and fired it without knowing it was her handgun can only be said to be reckless in and of itself, and certainly is something for the jury to consider. The second-degree manslaughter charge has culpable negligence, which is that the defendant did not intend the act to be harmful, but that an ordinary and reasonable person would have recognized the actions created a strong probability of injury to others. That is an awareness of the risk and a disregard of it. Again, speaking with respect to the decision to use a taser and instead using her firearm, which really applies also to both counts. She has been trained multiple times over her 26-year career, certified as a taser user since 2002, received trainings that the jury has seen, the court has seen regarding weapons confusion. It was an issue known to everybody in law enforcement. It was taught to her multiple times. She was aware of it, therefore, as the evidence, and by pulling her firearm instead, and acknowledging that she knew about weapons confusion in the sense that she had been trained on a taser. She knew enough to give a verbal warning for that taser. Shows intentional conduct that was done with an awareness of the risk and a complete disregard for the risk. Those are the basic, as I understand the motion, contested elements. There's certainly sufficient evidence. The state did not present conflicting evidence. I think what counsel is referring to is the evidence they led witnesses into saying, which I think where it was impeached. And if there are conflicting pieces of evidence, that's for juries to weigh. So the defense has not established a basis for their motion to be granted today because there is adequate evidence for the case to go to the jury. We would ask the court to deny the motion.
Okay. A judgment of acquittal can't be granted unless the trier of fact could not reasonably find the essential elements of the crime are established beyond a reasonable doubt. In ruling on that motion, all reasonable inferences and the evidence has to be viewed in the light most favorable to the state. That's the standard, and given that standard, I'm denying the motion for an acquittal. A couple matters from yesterday. I am going to allow the defense expert to testify about deadly force. Okay? That was a topic that was extensively covered by the state's expert. There's no prejudice to the state, obviously, to have the expert testify on deadly force, and there really are no surprises on what the expert's going to say. Then, Mr. Gray, I think you wanted to be heard on...
Should I go to the podium?
Yes, please.
Good morning again, Your Honor. Your Honor, I gave you exhibit, I can't remember the number of it. The exhibit is a certified copy of the conviction of Mrs. Wright, the first witness. You might recall, Judge, that before the trial, Your Honor ruled that we could bring up the fact that a felony conviction was, that she was convicted of a felony convictions, and the date of it was within the requirements of the law. Well, the state, in their presentation, said to the witness, well, you were convicted of a second-degree drug offense, weren't you? Something to that effect, which was not the judge's ruling. The judge ruled that you could just say felony conviction. And instead of embarrassing the witness more than need be, we refrained to get up, we restrained getting up and pointing out that the conviction was, I think, about a year ago, that she was convicted of this felony. Rather than do that, we decided to offer into evidence, since they now have presented the conviction, the court knows that they can do that, or we should be the ones that can do it within the time period required by law, that we would have a right to show the date of the conviction, because the jury has no idea when this conviction occurred. So we waited until we presented our case. We obtained, excuse me, Your Honor, we obtained a certified copy of the conviction, which is admissible under the rules of evidence, and it's self-authenticating, and we offer it as an exhibit. Thank you, Your Honor.
All right.
Excuse me, I'm sorry. For the purpose of showing that when she was convicted of the felony of drugs. If they're willing to stipulate to that, we don't need it. But if they're not willing to stipulate to the date that she was convicted of this, then we need it to prove it. Thank you.
Okay, you're not going to bring it up in your case in chief, obviously, are you?
No, I need that to show the date that she was convicted.
Okay. Does the state object?
Yes, Your Honor, the state objects. The court's prior ruling was that if Ms. Bryant was other than a spark of life witness, that she could potentially be impeached with an unspecified felony. That's how the court characterized it in the court's order. On direct, the state fronted the fact that there had been a conviction, which I believe was characterized as a felony conviction for second-degree controlled substance possession. That was fronted. Counsel had the opportunity to cross-examine on that point if it desired at that point, if the defense so desired. This issue was not raised at that time. Defense counsel essentially waived any right to cross-examine on that point. We fronted information that went beyond what was required under the court's ruling. That, however, does not supplant the court's direction, which was essentially that under the rules, the court has already decided that extrinsic evidence or other unrelated information about this conviction is clearly improper here. Had counsel wanted to inquire about the date of conviction at the time, I don't know that we would have taken issue with it. But at this point, with no foundation, with no witness, they now want to offer evidence, extrinsic evidence of a conviction that has absolutely nothing to do with the issues in this case, is completely collateral, is completely improper at this point. And we'd object, Your Honor.
Well, Your Honor, it's self-authenticating. We didn't cross-examine her on it because we followed the court's ruling. And what we're doing is attempting to show the date, and the date is shown on that without asking her a question. I was actually surprised when the state asked her, were you convicted of a second-degree drug conviction? I thought that was a violation of the court's rule of they were convicted of a felony. But they did that. I would not know what she would say as far as a date because I didn't ask it because of the fact I didn't want to further embarrass her. But we have the certified copy of the conviction. If they're willing to stipulate to the date of the conviction, we don't need it. But if they're not, we have a right to present evidence of the date of the conviction. It's not impeachment. It's our case in chief.
Your Honor, counsel had an opportunity to raise this issue, to bring this issue to the court's attention, to address any questions about date. I have not. I believe that counsel walked in with a copy of the conviction, showed it to my colleague at counsel table, and handed it to the court. My understanding is that document, although I don't have a copy myself, includes a lot of information that clearly does not pertain to the date of conviction. I presume it has information about, plea and sentence and things that clearly are not within the purview of the rule that governs prior convictions. And I do want to point out for the court that the court's original ruling was that there was essentially very little room for defense counsel to even inquire about this. We fronted it because we wanted to do that out of an abundance of caution, the fact of conviction. But other than the fact of conviction, none of this is relevant, Your Honor. And we object strongly.
Oh,
Well, they brought it up, Judge. We have a right to show the date.
okay. You had the right to show the date at the time that you cross-examined.
Well,
That's
I
right.
could have asked her, but that would have been a violation of your rule about a felony. I wasn't going to violate your rule, even though they did.
I'm not going to let this in.
Could we have a stipulation that would be allowed to stipulate as to the date of the conviction?
Is the state willing to just acknowledge the date of the conviction?
No, Your Honor. There's absolutely no basis for us to do that at this point.
And of course, the state is interested in justice, like they're supposed to.
Okay. All right. That's all right. The admission of this exhibit will be denied. It's marked 1007. Okay, Mr. Frank.
I'm being presumptuous, Your Honor, that I may address the court.
Yes.
I think, as you know, as a trial judge of many years, the certified copy of the conviction is used to impeach the witness if they deny the conviction. It doesn't go in as a substantive exhibit itself. So even the process here is completely wrong. But I understand the court's ruling. I just want to point that out, that to me, it's somewhat disingenuous to say we didn't want to embarrass her then because they didn't want to ask her while she was on the stand and look a certain way. Now they want to do it. Anyway, I'm sorry.
Well, you guys, I think we spent way too much time arguing this point, which is totally collateral.
Thank you, Your Honor. I'm sorry. Your Honor, I indicated to the court yesterday that we would object to Mr. Ijames testifying about deadly force opinion. I raised it so the court would be aware of it, that we would need time, but I do want to address it because I think it goes simply beyond what was raised yesterday about it. Your Honor, we received an order from the court. The court filed back in August, I believe. June 2nd of 2021 with an expert disclosure deadline.
Yeah, I already ruled on this.
But I haven't had an opportunity to be heard, Your Honor, and I think we have an opportunity to be heard. That's why I fronted it yesterday to say we need time this morning to address this. You will also recall, well, maybe you don't know this, but Mr. Eng and Mr. Gray were going to meet with Mr. Ijames last night. We have an additional disclosure. And so I want to address this because what we have here is flouting of the rules in the court's order. And the prejudice comes from not knowing what this witness is going to say, not what we know our own witness is going to say. So I would like to address that, Your Honor.
I'll let you continue. I didn't let you argue this morning on that point, but go ahead.
Thank you, Your Honor. The court's order required and cited to the rules of criminal procedure that require it as well, that disclosures of experts would be made by October 15th of 2021, and any rebuttal to those disclosures would be made within 30 days. The disclosure required all findings, opinions, or conclusions to which each expert is expected to testify and the basis for their findings, opinions, and testimony. Purposes for that are obvious, so that there is notice to be prepared for trial so the opponent can fairly meet the evidence that is going to be presented. As we recall yesterday, Mr. Gray objected because the witness had used one word, subjectivity, or subjective, that he couldn't find in the report. And at that
Actually,
point,
that is what I brought up, not Mr. Gray. Okay.
he brought the objection up and the court asked that. And what the court had said at that time, if it's not in the report, you're not going to allow it for testimony. Your Honor, here is our expert's report. It's 52 pages long, single-spaced. It's very thorough. It has captions, headings, opinions, explanations, the basis, all set forth in these 52 pages. The report that was disclosed to us from Mr. Ijames is a little over 2 pages long, Your Honor. The opinions in it really encompass less than 1 page. Most of them, in fact all of them, are very conclusory and simply state in one sentence an opinion. No basis for that, no discussion of what they will testify to support that opinion. I believe you have a copy of this. You're familiar with it. It is, to say the least, conclusory. The disclosure that the defense provided, Mr. Eng signed and filed, says simply that Mr. Ijames will testify that Officer Potter's decision to use a taser was appropriate and consistent with standard training and police procedure. Nothing about deadly force or the use of a firearm. Your Honor, before trial, when we met with our expert witness, this is a copy of what we disclosed to the defense. It's thorough, and according to Mr. Eng, painfully thorough, 4 pages long, single-spaced, with a complete description of our conversation with the expert at that time. We're complying with disclosure requirements about what our witness will testify to. Last night, I received an email from Mr. Eng. He sent it at 7:24 p.m., but I didn't see it until about 9:30 p.m. because I have a home life, right? We all get to go home and have a home life, so I didn't see it till 9:30 last night. It contains 6 sentences, 6 numbered sentences. I'm sorry, one is actually 2 sentences, but in 6 numbered lines that are single conclusory statements about what Mr. Ijames apparently is going to testify about. No explanation of the bases for that or what else he will testify about. So what we have, Your Honor, and yesterday, and I have a copy for this if the court would like it, and so we have been given no knowledge, no information about what Mr. Ijames is going to rely on to support his opinions. We just have these conclusory statements. There's nothing in the reports or this follow-up about his basis for the deadly force opinion. We disclosed our expert's report that has 3 or 4 pages on deadly force back in October as we were supposed to, and they were clearly on notice then that deadly force was an issue. They requested a jury instruction on deadly force, and yet we're getting disclosures about a deadly force opinion on the night before this witness is supposed to testify in the morning. Your Honor, this relatedly, the defense intends to call Tim Gannon today. The disclosure we got from Tim Gannon, November 8th, is provided by defense counsel when they met with him. It's a page and a half, and it is woefully inadequate. And just sort of interestingly, like the very first paragraph, says we talked with him about his education, his law enforcement career, working relationship with Officer Potter, mentions that she was the union representative, and then just says, we're summarized. So rather than telling us what information they got, it just says that it was summarized. We didn't get the summary. It goes on, Your Honor, to present very conclusory statements. The close proximity of her taser to Mr. Wright was not concerning under the circumstances presented, period. No basis for that opinion, no foundation for that opinion. Goes on to say her assumed use of the taser was reasonable and appropriate. No explanation as to the basis for that opinion or why he would offer that opinion. Then, Your Honor, we got a disclosure from an interview with Mr. Gannon on December 6th of 2000, so after trial had technically started, where he now offers, Mr. Gannon will offer an opinion about deadly force. Little to no explanation of the basis for that opinion, his foundation for that opinion. And so, again, what we're getting is they didn't have an expert talk about deadly force. Now they're trying to turn a former police officer who worked with Ms. Potter into an unnoticed expert witness who's going to offer an opinion in violation of the court's disclosure order and without what is required by the rule in the court's order as to disclosures for such opinions, even setting aside whether it's appropriate for a lay witness to offer a legal opinion as an expert. We followed the rule in the court's order to disclose our expert. Now they're trying to slip in somebody because they didn't. What we're seeing, Your Honor, is a pattern of flouting the court's orders and the rules and trying to litigate by surprise, not doing proper disclosures, not doing full disclosures, and just putting up a witness without letting us know, being able to fairly meet that testimony. That's not what the rules provide. Your Honor, and this is not, Your Honor, ineffective assistance of counsel. I'm not concerned about that because this is strategic, this is tactical, this is effective assistance of counsel. They are trying to represent their client in a way that the rules don't provide, but which gives them an advantage. We are asking, Your Honor, to not allow Mr. Ijames to testify at all because the proper disclosures were never made about the substance of his opinion, the support for his opinion, including the disclosure made last night that I, again, saw at 9:30 p.m. At a minimum, he should not be allowed to testify to anything, as the court said, that is not in his report. We don't expect that every word a witness says on the stand is going to be in the disclosures, but we expect the substance of it to be. I think the court recognized that yesterday in first raising the concern and then recognizing that the substance was there. And so what we're being required to do today is litigate without proper notice provided by the rules in the court's order. So we are asking you to prohibit his testimony, Mr. Ijames, at a minimum to limit it to exactly what is the conclusions in his, the only disclosures we got. And with respect to Mr. Gannon, first of all, to not allow an expert opinion. We have objected in the past to allowing lay witnesses who are fact witnesses to come in and testify to opinions. I think the court's ruling was that they could testify that what Officer Potter did was consistent with their training. We still object to that, but we more strenuously object to allowing them to offer an expert opinion about whether it was reasonable. It's a legal conclusion. It's subject for an expert opinion, as we have done, not for sneaking a witness in to do it. And we would ask the court to not allow former Officer Gannon to testify to his opinion about deadly force. So that is our motion, Your Honor, this morning. And unless the court has questions, I'll leave it at that.
Mr. Rain, did you want to respond?
Well, we had a discussion about this yesterday in terms of Chief Gannon, former Chief Gannon. He's a lay witness. He's not an expert witness. He has more training at 25 years than Mr. Stoughton at 5 years. And, we met with him, and the state finally gave us their voluminous jury exhibits. We showed him a couple more exhibits than he had. And we asked him, what his view of it was, and you've already ruled that he's qualified. If they have a problem with Mr. Gannon, they could have called him. I mean, he certainly would have interviewed with him. They didn't make any attempt. In terms of the Ijames testimony, we believe in brevity rather than a 50-page report. Mr. Ijames is not charging us anything. I gave a detailed summary. There was no objection to it. They never complained about it until today. We did meet with him last night to go over the Stoughton testimony on the points he would disagree with. And as we mentioned yesterday, an expert's entitled to listen to the whole trial, and he has listened to the critical evidence, namely Lucky Johnson, the trainers, and Stoughton. The rest of it's kind of fluff, really. DNA, really? Firearms evaluation, really? And so he has, 98% of what I was going to ask him was about the taser, but, they've opened the door here. The Stoughton testimony, and particularly the Johnson testimony, is critical. He was unaware of it, and so he's going to answer it. And it's not going to be extensive. But I find, there's no prejudice to them whatsoever. We just got 3 hours of Stoughton. I'm going to get a little bit of time on Ijames. And again, if they had a problem with it, they should have told us about it beforehand, or at least called him. I mean, he's quite accessible, as you'll see. So, it's much ado about nothing, and we appreciate your ruling. It should stand. I mean, this is a pattern that the state repeats over and over again. They don't get a ruling. They spend 20 minutes lecturing you on why your ruling's wrong. And then here we are at 9:40 when we're ready to go. So we're ready to go.
All right. Let's deal with the expert first. I am going to allow the defense expert to testify about deadly force, mainly because there's really no prejudice here. The basis of his opinion are the facts in the case. And generally speaking, the facts in the case are really not in dispute. So, absent prejudice to the state, and I think it's legitimate to have a defense expert respond to claims that were made during the trial. I'm going to let him testify as to deadly force. With respect to former Chief of Police Gannon, I previously ruled that police officers could testify that conduct was in accordance with their training. I also believe that the chief of police in this situation should be able to testify whether or not, under the facts presented, this was improper, inconsistent with Officer Potter's training, and unreasonable force. He's the chief of police. I mean, I'm assuming he got that position because of his training and his knowledge of what is or is not proper to do as a police officer. Okay, let's get the jury in. Thank you, Deputy. Oh, excuse me. Can you tell the deputy hold up one moment? Oh, okay, just one moment. I just wanted to cover one thing. Ms. Potter, do you still want to testify, or have you changed your mind?
Yes, Your Honor, I'll testify.
Okay. And you don't need any more time to think about that?
No, Your Honor.
Okay. All right, Deputy.
Excuse me, for the record, we have talked at length about that.
Okay.
He wants to testify.
All right. Okay. Yes, please.